All right, council member, you can begin when you're ready.
Good afternoon. I'm Robert White, council member at large and chair of the Committee on Government Operations and Facilities. Today is Wednesday, October 6, 2021, and the time is now 1:08 p.m. I'm calling to order this hearing of the Committee on Government Operations and Facilities regarding B24-215, the Sexual Harassment Data Collection and Reporting Act of 2021, and B24-229, the Human Rights Enhancement Amendment Act of 2021. As members of the committee are aware, the Office of Human Rights came under our jurisdiction earlier this year, and we've gotten to spend a lot of time discussing agency operations and staffing. I'm really glad that our oversight and budget work has already spurred some changes at OHR, changes that should help the office vigorously and faithfully enforce our local and federal anti-discrimination laws. But today we come together to review proposed changes to our foundational civil rights law itself, the Human Rights Act of 1977. The HRA is a magnificent old statute. Passed in the first years of Home Rule, it sets a bold vision for a district free of discrimination on any basis but individual merit. It bans discrimination in housing, employment, public accommodations, and education. The council has updated it from time to time, and it currently enumerates over 20 protected characteristics. But discrimination takes many changing forms, and we, as legislators, have to be attentive if we want the district to remain a safe place for inclusive flourishing for everyone. This year, I've introduced B24-229, the Human Rights Enhancement Act of 2021, and I'm very grateful to have the support of council members Nadeau and Pinto of this committee as co-introducers, along with council members Che, Silverman, and Lewis George, plus council member Allen as a co-sponsor. But this bill represents much more than our efforts. At the heart of this bill is a provision that homeless residents and their advocates have pushed for years, and that several of us supported through multiple prior introductions, adding homelessness status as a protected characteristic. I'm grateful to everyone who has shown up to testify about this need in the past. In addition, based on input from advocates who've experienced homelessness, I've added a provision to make sure law enforcement officers who so often are called in to remove homeless people from places where they might have the right to be, understand and are prepared to honor those new protections. The bill would also clarify some definitions in the HRA to make sure that the courts that have to interpret the law don't stray too far from its intended effect. We would spell out that when the HRA protects employees, it includes people working as independent contractors who don't deserve to be left vulnerable to discrimination. And the bill also lays out a definition of sexual harassment, giving detailed guidance on how to identify it. We're also going to consider B24-215, the Sexual Harassment Data Collection and Reporting Act of 2021. I introduced this measure with the support of 8 colleagues, including 3 fellow committee members, to make sure that any reports of sexual harassment within the district government are promptly reported to the relevant agency's designated sexual harassment officer, and then included in an annual report to the council. Centralized reporting of sexual harassment against district employees is another initiative that I'm proud to spearhead after others have already done some great work. In particular, I want to also acknowledge that Councilmember Allen's Sexual Misconduct Sunshine Amendment Act of 2018, which would prohibit non-disclosure agreements impacting reports of sexual misconduct and require an annual report on sexual misconduct settlements. All 13 council members at the time signed on to that bill as co-introducers, myself included, and the same was true when Councilmember Allen introduced a similar bill in 2019. My bill complements the other piece of legislation by requiring reporting. SHOs are positions that already exist by mayoral order, and this bill would direct them to send statistics on sexual harassment allegations to OHR to be compiled into an annual report. By setting up these lines of communication, we will bring visibility to any patterns of harassment affecting our fellow public servants and allow us to hold our agencies accountable for their employees' well-being. I'm looking forward to a productive discussion of both these bills And I now want to turn to my colleague, Councilmember Brooke Pinto, who is a member of this committee. Welcome, Councilmember Pinto. If you have a statement, you can feel free to give it at this time.
Great. Well, thank you so much, Chairman White, and thank you for having me and for holding this hearing today and introducing these really two important pieces of legislation. I was thrilled to co-sponsor both of these bills with you and believe that they are critical steps to ensuring that the district is a safe place for all of our residents. The Sexual Harassment Data Collection and Reporting Act of 2021 will help us collect data on sexual harassment complaints within the DC government and ensure that there are consequences and accountability for those who make our workplaces unsafe. This will also help assure those who experience sexual harassment that if they do come forward, which is an extremely hard thing to do, that their complaints will be taken seriously. And so much of our progress in this space really depends on accurate data being collected and understood. We have to take an honest look about how prevalent sexual harassment continues to be, not only on the street, but in our workplaces. And the Human Rights Enhancement Amendment Act of 2021 will provide protections to our neighbors experiencing homelessness so they cannot be discriminated against because of their housing status. As we will hear from some of our witnesses today, our residents experiencing homelessness are frequently denied employment or housing opportunities in our city. And this is completely unacceptable and makes it nearly impossible for residents to overcome homelessness. It's especially important now that we have hundreds of new vouchers that our neighbors experiencing homelessness are not subject to voucher discrimination or other forms of discrimination. We have a real opportunity this year to make sure that these vouchers that are becoming available are utilized expeditiously, safely, and fairly. And we have to make sure that every piece of the housing infrastructure is working together towards that goal. So I look forward to hearing from our witnesses today in support of these two bills, or what they have to say about these two bills, and I look forward to supporting these two bills. I want to thank you again, Chairman White, for your leadership in these spaces.
Thank you again, Councilmember Pinto. Before we hear from the agency, we'll hear testimony from our public witnesses. Everyone should have received a copy of the witness list yesterday. So I'll call the witnesses in the order that they appear on the list. A couple witnesses let us know this morning that they would not be able to make it due to unforeseen circumstances. When I call your name, if you're a witness, the staff will promote you to a panelist so that you can testify. When you're promoted, you will drop out of the hearing momentarily and come back in as a panelist. And at that time, you will be able to unmute yourself. Public witnesses will be provided 4 minutes to testify. So we will now move to our panel of public witnesses. Lynn Amano, Jonathan Puth, Jesse Rabinowitz, Kate Coventry, Reginald Black, and Robert Warren. Good morning, Lynn. You can begin when you are ready.
Great. Thank you. Thank you, Chairman White, for the opportunity to testify today on this important piece of legislation. I am speaking to you today as the advocacy and community organizer for Friendship Place. Friendship Place is a well-known and established provider of housing and services for those experiencing homelessness. And as such, we know the challenges regularly faced by those who are currently or were formerly without a stable place to call home. We are testifying to you in support of the changes suggested in the Human Rights Enhancement Act that you've put forth in coordination with Council members Che Nadeau, Pinto, Silverman, and Lewis George. And this bill would codify homelessness as a criterion protected from discrimination. It would add homeless status to a substantive list of things in which individuals will be protected in areas including employment, housing and real estate transactions, public accommodations, educational institutions, motor vehicle insurance, and DC government programs, facilities, services, and benefits. In addition, police enforcement would be educated in the impact of their actions and decisions on those experiencing homelessness. Our staff and clients at Friendship Place have direct experience of the kinds of discrimination addressed by this amendment. For example, our Aim Higher employment program helps individuals experiencing homelessness find jobs that they can work with their current skill set. And that's our Jobs First model. But Aim Higher has encountered discrimination in employment, including claims of people lacking culture fit or assumptions about the individual's capabilities to perform on the job, both before and after employment. In one case, one of our employers participated in a hiring event in May of 2019, and the employer then found 12 of 20 candidates presented by Aim Higher to have met qualifications and be good fits for their jobs. But 2 months passed without further communication, and upon follow-up, the employer expressed to us that they were able to find other candidates and so did not need candidates experiencing homelessness from a small nonprofit. Past clients have not been hired, although they met other qualifications when employers noticed that their permanent address was a shelter, transitional, or subsidized housing, and employers have been known to drive by permanent addresses to see where their employees might be living. Clients in other programs have had these experiences as well. Property owners have made blanket discriminatory statements like, "We don't take vouchers" when clients are seeking housing. They may use many of the same rationale as employers when it comes to credit, history, length of employment, and housing status that work against those who have experienced housing insecurity. And in the district, we do claim to want to make sure that everyone is able to support themselves and to find stable housing on their own. And we really owe it to those who've experienced homelessness to not have that fact haunt every event of their lives moving forward. Thank you to Chairman White and the other council members for co-sponsoring this bill. At Friendship Place, we believe that everyone deserves a safe, stable place to call home. And until all DC residents can obtain actual stable housing, the city can at least protect them from undue discrimination being piled up on top of all of the already challenging situations they face. Thank you.
Thank you very much. Next witness is Jonathan Puth. Welcome.
Thank you, Mr. Chair. Councilmember White, members of the committee, I'm very pleased to testify regarding B24-0299, the Human Rights Enhancement Act of 2021. I've submitted a more detailed statement, and I'll summarize briefly my testimony. WHALE is an association of over 300 attorneys who routinely represent individuals in employment matters. My testimony today is geared toward the legislation as it affects the employment provisions of the DC Human Rights Act. I'm also a member of a law firm here in DC, a small law firm that's 100% devoted to the interests of individuals to be free from discrimination and retaliation. The important thing to note here is that the council has always worked consistently to ensure that the DC Human Rights Act is the most robust law that it can be in the country to, as it states in its purposes, to secure an end in the District of Columbia to discrimination for any reason other than individual merit. We enthusiastically support the efforts of our fellow advocates and inclusion of homelessness as a protected category under the law. It's clear that individuals who are homeless encounter enormous difficulties and barriers to employment, which only persistently makes things continue to persist for them and without housing. We fully support the language to clarify that independent contractors are covered under the Human Rights Act. I want to emphasize that as it is right now, the independent contractors are covered under the Human Rights Act. It clearly covers individuals. It protects individuals, not employees, from discrimination, from retaliation, and it always has done so. Unfortunately, a non-binding decision of a federal court has determined that the Human Rights Act does not cover independent contractors. We believe it's important for the record to reflect that this is a clarification, not a change in DC law, and that it covers individuals who now may have claims. With the increasing efforts of employers to move employees to independent contractor status, though, this is a critically important provision. We also applaud the efforts by the committee to reform the legal definition of harassment in the Human Rights Act. We do recommend some changes. Several jurisdictions have undertaken efforts to get away from the severe or pervasive standard for harassment that was established with the very first recognition of harassment as discrimination 35 years ago by the Supreme Court. Our law is interpreted the same way federal law is in this area. However, severe or pervasive has been interpreted in a way that has excluded some horrific harassment from coverage under the law, including the Human Rights Act. And I've cited those cases in my written presentation. We'd be very glad to work with the committee, but we suggest basically removing the word severe or pervasive from the definition that is within the Act. We also have some other suggestions as well that some we've put into the written testimony, but others we're glad to work with the committee. We think this is an excellent, good start, and we look forward to making these important changes. Thank you.
Thank you very much, Jesse Rabinowitz.
Councilmember, Jesse is working on encampments and said he would submit written testimony.
Okay.
And can I just ask a quick clarifying question? Are we going to have rounds of questions?
Of course.
Okay, so after everyone goes.
But you don't get to ask questions. I just want to clarify that.
I know. I just want to make sure I stuck around.
Yes. No. Please do.
Okay.
And I appreciate what Jesse is doing. So I understand why he's not here. So you can proceed, and we will have his written testimony as part of the record.
Okay. Thank you.
And you can begin when you're ready.
Okay. Chairman White and Councilmember Pinto and other members of the committee, thank you for the opportunity to testify today. I'm Kate Coventry. I'm a senior policy analyst at the DC Fiscal Policy Institute. DCFPI is a nonprofit organization that promotes budget choices to address DC's economic and racial inequities and to build widespread prosperity in the District of Columbia through independent research and policy recommendations. I'm here today to express strong support for B24-0229, the Human Rights Enhancement Amendment Act of 2021. DC residents experiencing homelessness report facing various types of discrimination because of their homeless status and have no recourse under the current Human Rights Act. B24-0229 would address this issue and allow residents to file complaints that could result in fines, compensatory damages, or reinstatement of jobs. Homeless DC residents report discrimination, so DC should act to prohibit this discrimination. B24-0229 would make homelessness a protected class under the DC Human Rights Act, which prohibits discrimination on the basis of race, gender, sexuality, and income source, among other traits. This legislation would offer recourse to homeless residents experiencing homelessness from discrimination in employment, places of public accommodation, educational institutions, public service, housing, and commercial space. It would allow residents to file a complaint with the Office of Human Rights that could result in fines, compensatory damage, or reinstatement of jobs. In 2014, the National Coalition for the Homeless and graduate students at George Washington University's Trachtenberg School of Public Policy and Public Administration surveyed individuals experiencing homelessness in DC to learn about their experiences of discrimination. Nearly 93% felt they'd been discriminated against because of their homelessness by one or more kinds of institution. More than 70% reported being discriminated against by a private business, and nearly 67% reported being discriminated against by law enforcement. Nearly 50% reported being discriminated against by medical providers, and 44% reported discrimination from social service providers. Respondents provided specific examples, such as being turned away from a business or being denied medical care. While 85% of individuals experiencing homelessness are Black, and many others belong to other protected classes in the Human Rights Act, discrimination against people for their homelessness is separate and distinct from other forms of discrimination. For example, a woman is denied service at a restaurant because she appears homeless, not because of her gender. B23-0229 will address this discrimination. The district should join the 3 U.S. cities, 3 states, and Puerto Rico to outlaw discrimination based on housing status by passing B23-0229. Thank you for the opportunity to testify. I'm happy to answer any questions.
Thank you very much. And Reginald Black, welcome.
All right, can you hear me?
Yes.
All right, good. Good afternoon, Councilmember White, members of the Committee on Government Operations and Facilities, and district residents. My name is Reginald Black, and I am a native Washingtonian, Ward 4 resident, and the Executive Director of the People for Fairness Coalition, as well as a lived experience appointee on the Interagency Council on Homelessness. I'm here to testify in support and to make recommendations to Bill 24-0229, the Human Rights Enhancement Act of 2021. This crucial legislation is a great step in the right direction in terms of producing racial equity in the District of Columbia, as well as the ultimate way of accomplishing the mission of the late, great Michael Stoops, who I worked with personally on many different initiatives, including the annual Homeless Persons Memorial Day and Vigil, as well as through the evolution of Street Sense Media. The homeless community is a vulnerable community in which things do go wrong during the course of the day that make life difficult for these residents. We are pleased that the council did hear that we are seeing discrimination amongst our most vulnerable population, and adding the definition of homelessness to each and every protected class and trait under the DC Human Rights Act is greatly needed. We conducted a study in 2014 in which it shows that 93% of all unhoused respondents felt they had been discriminated against. 70.3% of African Americans reported that they felt discriminated against by law enforcement. And 75% of whites felt private businesses discriminated against them. Overwhelmingly, men thought that law enforcement was the source of discrimination at a rate of 66.6%. What was even more staggering was that we found women perceived discrimination from social services and medical services at 42.9% and 58.1% concurrently. When homeless people are removed from an establishment, the Metropolitan Police Department, MPD, are called to mediate the situation. At that time, a potential consumer of homeless services cannot make a complaint if they wish to make one. Corporations are often reluctant to give a person who appears not to be in good standing a complaint line. This is why we supported the creation and passage of the Michael A. Stoops Anti-Discrimination Amendment Act previously, and are here today to support the Human Rights Enhancement Act. Some of our recommendations include making sure that there's language that will add the definitions to homelessness to each and every protected class, and that there are the following implementation steps either added to the Office of Human Rights Regulations or to the bill itself. 1, agencies like the Department of Behavioral Health, the Department of Human Services, the Metropolitan Police Department, etc., will assist to streamline the human rights complaint intake process. 2, that there's significant funding to implement investigations. We would like to recommend that we would like to recommend a recurring funding level of at least $1 million a year. This will greatly improve our infrastructure to conduct thorough human rights investigations. 3, all of our social services should incorporate a racial equity lens and should have a clear understanding of their role in the experience of discrimination. And we applaud the efforts you are making in making this legislation possible. We want to give every resident the impression of inclusion. And this particular bill is a great way to start that framework and effort in DC. to make us a world-class human city. I thank you for the opportunity to testify, and I'm happy to answer any questions you may have.
Thank you very much to all the panelists. Let me start with you, Mr. Black. We'll do a 10-minute rounds. So I want to run through your recommendations. First, the recommendation that Department of Behavioral Health, Department of Human Services, and MPD assist with the intake process. Can you talk to me a bit more about how you see that working?
Mm-hmm. So normally under the All Rights, a person who has to file a human rights complaint, they have to either physically go to 441 4th Street, or they have to pull down an online form from the Office of Human Rights' website. We want to make it possible that first responder agencies like DBH, like MPD, those who are on the scene first, are the ones that can help initiate that process by either providing the physical form for the complainant to fill out and submit that, or to help them access it online. Also, we would like to see some of the police or concurrent police reports, if there's a bar notice, added to the human rights intake form. We want to try to get information as fresh as possible. We want to make sure that while first responders are on the scene, and while everyone's memory is fresh, and while you actually have the parties involved on the scene, that you're able to collect the information, submit the complaint form in an expedited fashion, because usually a person has to, like I said, either go online themselves or go to the Office of Human Rights' office to do the intake process. If we can get first responders in on the training of how to complete the forms or assist consumers
so let
to complete those forms.
Let me ask this. So if someone calls 911 and says, you know, I'm being discriminated against, I could see that prompting, you know, a first responder to show up and maybe initiate the intake process. But like, how would you see Department of Behavioral Health or Department of Human Services, like where would they kind of come into contact with somebody facing discrimination?
So usually MPD in these cases are the first responder. And so we want to make sure that any concurrent services that MPD and other agencies like this engage are fully taken account into what the resident is reporting to that particular first responder. In cases of severe mental illness, maybe if someone calls 311 and DBH comes on the scene and you know, an unhoused resident says, well, hey, I feel like they may be saying it to the accuser or someone trying to remove them from an establishment. They'll say, I feel like you're being discriminatory upon them. There would be policies and protocols, you know, related to first responders understanding the situation while they're investigating and talking to folks. They can then determine, does that person want to actually file a complaint? And that's how that process would be initiated, through some of those on-site interviews that are conducted during the situation. And so we want to make sure there's guidance for the community-based officers as far as MPD is concerned. We want to make sure that when folks are responding to severe mental illness emergencies, that they're able to help as well. And of course, the Department of Human Services should have staff available with even in their own agency when people do perceive discrimination occurring right there. Like I said in my testimony, I also included an addendum to show that in most cases, women at 42.9% actually perceive discrimination happening within a society. In that, some folks at DHS may be engaging in that, and so we need to take every step available to make sure that a person can make a complaint, even if you have to remove that person. They should be able to make the complaint first.
I appreciate that. Let me move to Jonathan Puth, and I appreciate the recommendation. So the recommendation that we move away from the severe or pervasive standard for harassment. So I'm certainly open to amending the bill, but as it's written, right, we define harassment as conduct that is severe, sufficiently pervasive, or that has the purpose of effectively or unreasonably interfering with the individual's work performance, et cetera. So it seems to me that we went more broad and would therefore kind of capture, protect people more. But it seems like you are saying that we have narrowed the door. What am I missing?
Thank you very much, Mr. Chair. I think the issue is that courts, particularly federal courts, which consider an awful lot of the Human Rights Act claims, either because they're sitting in diversity or because the Human Rights Act claims are brought with other federal claims, that they tend to bring forth the whole body of law and rely on the whole body of law, consider it in parallel with federal law. And there's a lot of very bad law, as I have outlined in my written testimony. And so the idea is to distinguish the Human Rights Act from that body of law in a way that will help ensure that we are not buying into those negative interpretations of human rights protections. For that reason, we think it's best to leave it behind. Other jurisdictions have done so, such as Montgomery County. Other jurisdictions and New York State. Other jurisdictions, such as Maryland and Virginia, have been making efforts to do so as well.
So for Montgomery County and New York State, have they moved toward the language that we also have in here, unreasonably interfering with an individual's work performance?
They have moved away from the severe or pervasive standard, yes, and toward broadening the definition to take into account the wide variety of circumstances that may constitute unlawful harassment.
Okay.
And I should say we would like the opportunity to work with the committee on particular verbiage here and there. There are a couple of things that we think with a tweak or two could be made much more inclusive. And given our experience as litigators on behalf of targets of harassment, we think we're pretty well situated to offer that expertise.
Okay, I appreciate. We would be more than happy to work with you. We want to get this right, so we'd appreciate that. Let me ask a question of Lynn Amano. So the example that you use with candidates who went to a job opportunity, and for 12 of 20 to essentially be deemed qualified, but it seems like none got a return call. Is this something that you see in your work as common, or is it something that's serious, but it happens from time to time? I'm sorry, you're on mute.
I thought I unmuted myself. So yes, we do experience that the discrimination is common. Like our organization, Aim Higher, works specifically just with people who are experiencing homelessness. So they work very hard to build relationships with employers to help break down some of that tendency to discriminate against individuals in that position. And so I would say that if anything, we sort of have a better track record of overcoming that discrimination, but it's definitely something that makes that door harder to open on the front end for our potential employees.
Based on your experience, do you see any other gaps that we need to try to close? Because one thing, that's always difficult in discrimination cases is proving discrimination. So are you seeing anything at this point that you think we need to look at tweaking or tightening up in the legislation?
I think that the legislation addresses it to the extent that it can. Obviously, there's always it's a difficult thing to enforce when it's a guideline, as you said, and sort of difficult. And I think it's particularly challenging because of the type of homelessness in DC that, we have the vast majority of people, for example, experiencing homelessness are people of color. So there can be overlaid discrimination that's going on, and that can make it a little more difficult to separate out specifically the homelessness piece from racial discrimination as well. Mm-hmm. And so I think that's a challenge that sort of has yet to have a real ability to address it and to enforce it.
Do you have any thoughts based on your experience about if this bill passes and becomes law, how do we get the word out so that people know that this is now covered under the HRA?
Keep muting myself. That's a good question. I mean, I think having the hearing is definitely a helpful part of that. I think perhaps reaching out to especially the organizations who are working on that issue, I think that work with people who experience homelessness, because those would be the people who are most likely to, be visible witnesses of that going on as well. I think for the individual people, it's a much more difficult task to get out to individuals. And I'm wondering if like Reginald or some other people might have some suggestions for that as well.
Reginald Black, do you have any recommendations about how we get the word out if this bill passes? How do we make sure people know that homelessness is a protected trade under the HRA?
So if we get this bill passed, it'll allow us to bring more cases. So the metric you can use there will see an increase in cases coded homelessness status. I even tried a case on personal appearance in which I walked into an establishment. And one of the other contexts, I work for Street Sense Media. Street Sense Media has a vest that says the word homelessness on it. So I'm in there and now I'm getting told I only have 30 minutes to eat. The manager wants this said to me. So in a situation, I could not prove that homelessness was actually the thing fueling this negative interaction. So you'll start to see cases under the homelessness status being coded. There is very little data on actual complaints that fully go through on things like personal appearance. That was one we tried to use. You see ones on race, but they don't necessarily apply to, when people are within programs or within the department and they face discrimination, right? And for the most part, people who are unhoused, they don't know the complaint process. This is why we need first responders to be in on that process, because when they are perceiving and feeling that they're being discriminated against, then they should be able to file a complaint based on their actual situation. And calling homelessness out in that definition will allow us to now thoroughly investigate. When OHR gets a complaint form in and it says that this is what we're investigating, now you can start to pull camera, pull more statements, pull more audio. You can take a look at the police reports. You can take a look at if there is some service engagements or things like that, as far as DBH in their system, to see what actually happened in that situation. But right now, we have to have that definition called out and be able to code the cases so that now we can record the data on the cases being filed, the investigations, and making sure that we also keep accurate records of those that actually go to litigation or are solved through mediation.
Okay. Okay. Hopefully we can get the word out otherwise too. Maybe Street Sense, the Washington Post, hopefully they will, pick this up and start to get the word out. Kate Coventry, you had cited a GW study. Do you happen to know if the committee has that?
I didn't send it, but I can.
Okay.
Could I briefly answer the previous question?
Sure, please.
I think, putting the word out through the Interagency Council on Homelessness would help. That way all the providers would know, partnering with DHS and CFSA and the other groups that contract with providers to make sure that's part of whatever's in their contracts, or whatever materials they get from the agency would be helpful. And then specifically consulting with the Interagency Council on Homelessness Consumer Committee, because those are the folks that work with who have lived experience for the most part, or all of them do, and can kind of say how we would know, how they would know. I would also flag we have a free text system in the homeless services system called Hope Source One.
Yeah.
And we could send, once the law was implemented, we could send a notice that way. So.
Okay. Yeah. Great resource. I volunteered with them a few years ago. So great idea. Thank you for that.
But the report that you
share the GW.
But the report you mentioned, I added
that.
Sorry, but the report you mentioned, I have it in the addendum. That report we did. Yeah.
Thank you very much. I know I'm well over time. My colleague, Councilmember Pinto, I'm not sure if you are still with us. If so, do you have any questions? All right. Well, I want to thank our public witnesses very much. Let me make sure my team is not telling me that I missed something. No. I want to thank you all for taking the time to testify. I'm hopeful that we will be able to, continue to sharpen the bill a bit and get it passed into law. Particularly right now, given the experience that you articulated, eating at a restaurant, Mr. Black, the things that we're seeing with the homeless encampment clearings, this is a time where we really need to focus on respecting the dignity of human people. And, it's unfortunate that you have to legislate dignity in some ways, but we have seen, you all have seen firsthand experiences of discrimination and harassment that we have to tighten the law to make sure we're protecting all residents in our city. I'm very, proud of the age of the Human Rights Act. It shows that long before any of us were doing the things that we're doing, there were people in this city focused on making sure all people are protected and able to move and excel based on merit. And, it's still an aspirational goal, but I think it's still a goal that we hold very dear. So I appreciate all of you in helping us craft and sharpen this bill. My hope is that we can sharpen it a bit more and get it to the full council for a vote. So thank you all very much.
Thank you, council member.
Thanks.
And
I know he doesn't want me to say it, but I'm going to say it. Jonathan Puth is my old boss from law school, and it's very cool to see him and work with him in this capacity.
You're the boss now.
Thank you. I also, since I said that for the record, let me know Jonathan was really kind to work with. I was in law school, didn't know what I was doing, and he's always so patient. So I appreciate it very much.
Thank you.
Thanks. Next, I want to welcome our government witness. And I'm just going to take just a second to get queued up. As she comes on, I want to welcome Nin Kine, Interim Director of the Office of Human Rights. I know that you have not been in the role very long, so I appreciate you all joining us and submitting testimony. Because you've been with the agency, so you know it's the practice of this committee to place our government witnesses under oath. So I would ask that you raise your right hand. And is there anybody from your team who may be answering questions as well?
I don't anticipate so at this time, Council.
Okay, then we'll just swear you in. Do you swear or affirm under penalty of perjury that the testimony you are about to provide to the Committee on Government Operations and Procurement and Facilities, rather, is the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. Again, welcome. Congratulations on the new role, and very, very much look forward to working with you. So you can begin your testimony when you are ready.
Thank you, Chairperson White. I look forward to working with your office and committee as well. Good afternoon, Chairperson White, committee members, and staff of the Committee on Government Operations. My name is Min Kine, and I am the Interim Director for the Office of Human Rights. Thank you for the opportunity to discuss Bill 24-0215, the Sexual Harassment Data Collection and Reporting Act of 2021, and Bill 24-0229, the Human Rights Enhancement Amendment Act of 2021. As you know, the Human Rights Act of 1977 established the Office of Human Rights to provide administrative relief through investigation, mediation, and where probable cause is found, a public hearing. Since its establishment in 1977, OHR has been enforcing several laws in addition to the Human Rights Act. They include the Protecting Pregnant Workers Fairness Act, the Fair Criminal Record Screening Amendment Act, popularly known as Ban the Box, the Fair Criminal Record Screening for Housing Act, the Unemployed Anti-Discrimination Act, the Youth Bullying Prevention Act, the DC Language Access Act, the DC Family and Medical Leave Act, the DC Parental Leave Act, certain parts of the new Tipped Wage Workers Fairness Act, and the Racial Equity Achieves Results Act, and finally, the Anti-Retaliation and Non-Interference provisions of the Universal Paid Leave Amendment Act. In addition to the laws I just mentioned, OHR has work sharing agreements with the Equal Employment Opportunity Commission, as well as the U.S. Department of Housing and Urban Development, in order to investigate claims filed under Titles 7 and 8 of the Civil Rights Act of 1964, the Age Discrimination in Employment Act, and the Americans with Disabilities Act. As a complement to our enforcement work, OHR has also conducted multiple educational outreach programs throughout all 8 wards, as well as providing EEO trainings for our government employees. In the last fiscal year, OHR's outreach portfolio has increased significantly to include such things as overseeing sexual harassment training in the tipped wage industry, working with community partners to develop a bystander intervention training, which aims to combat street harassment, and collaborating with our sister agencies to develop a racial equity and inclusion training program. Having discussed the breadth of OHR's work, I will now discuss Bill 24-0215, the Sexual Harassment Data Collection and Reporting Act of 2021, which seeks to require district agencies to collect data on sexual harassment complaints and the Office of Human Rights to compile such data and submit an annual report to the Council. The executive is in support of this effort to compile data. However, we would like to work with the Council to clarify the intended coverage of the bill and to ensure certain provisions, such as the role and responsibilities of a sexual harassment officer, whom we refer to as SHOs, are consistent with Mayor's Order 2017-313. As you may recall, the mayor issued this robust order in December 2017, making clear that the district government does not tolerate any form of sexual harassment in the workplace. Among other things, this order required training for all employees and established a centralized process for reporting sexual harassment complaints. In the years following the order, the executive, through OHR and the Department of Human Resources, has been working diligently to fully implement this policy. As a result, I'm happy to share today that all agencies under the authority of the mayor that are required to designate a SHO are in compliance. I can further report that over the last 12 months, district government SHOs who are responsible for receiving and investigating complaints of sexual harassment at agencies have participated in the following. 1, an annual full-day SHO training last December. 2, brown bag trainings on various topics in February and May of this year, with another brown bag training coming up this month. Because the SHOs already have significant investigatory responsibilities along with their regular workload, we recommend the agency data collection responsibilities of Bill 24-0215 not solely rest on the shows. Instead, the bill should permit agencies to designate the most appropriate individuals suited to efficiently perform this function. Next, in order to obtain comprehensive data and to align with other existing deadlines, we recommend mandating this requirement at the start of fiscal year 2023 rather than calendar year 2022. Finally, because this program will add significant weight to OHR's existing work, additional resources would be needed to implement the legislation. Moving on to the next bill, B 24-0229, the Human Rights Enhancement Amendment Act of 2021 proposes to, 1, add homelessness as a protected trait, 2, include independent contractors in the definition of the term employee, 3, require OHR to provide training for law enforcement personnel, and 4, define what constitutes workplace harassment. I will address each of these proposals in turn. First, the executive supports the council's efforts to protect one of our most vulnerable populations, individuals experiencing homelessness. And we are working with the other district agencies to better understand the potential operational and programmatic impacts of this legislative proposal. Next, with respect to adding independent contractors to the definition of the term employee for purposes of prohibiting discrimination, because this proposal has the potential of resulting in a number of varying legal consequences, the executive would appreciate an opportunity to discuss the intended purpose behind this proposal and what specific issue the council seeks to address through this legislation. Regarding the bill's proposed requirement to educate law enforcement personnel, the executive is in support of training, but we would like to gain a better understanding of the intention and coverage of this provision, including such things as who would be included under the term law enforcement officers. While OHR is well suited to partner with MPD, for example, to provide training on the Human Rights Act and how to refer cases to OHR, we would need some time to consider the most appropriate organization to deliver a training on the, quote, impact of law enforcement decisions on people experiencing homelessness, end quote. Last, but certainly not least, I will address B 24-0229's proposal to define the meaning of the term harassment and sexual harassment in a statute. As many legal practitioners here are undoubtedly aware, the concept of hostile work environment, the legal theory under which harassment claims are examined, evolved through a series of judicial precedent and legal guidance from the EEOC over several years. The present language in Bill 24-0229 breaks away in part from this precedent, and the impact of such a departure is one that should be discussed more fully before codifying. That said, the executive's position is that this sort of undertaking is better implemented through rulemaking, where the stakeholders will have more opportunities to discuss and exchange ideas for meaningful ways to improve the law. Again, the executive is open and willing to work with the council to better understand the impetus behind this provision. But as it stands currently, the proposed language is somewhat at odds with existing legal principles and practices. And from an enforcement perspective, it stands to bring confusion to an already established mechanism for determining whether a given conduct constitutes unlawful harassment. Additionally, OHR foresees a great amount of litigation from the bill's language prescribing the specific circumstances that should not prevent a fact finder from reaching a conclusion as to whether a given conduct amounts to unlawful harassment. Of course, more litigation and debate are not what is needed to expediently resolve these already very complex and consequential cases. In sum, if the intention is to broaden what constitutes sexual harassment or to clarify the legal standard for establishing a sexual harassment claim or any harassment claim, in particular, what legal elements should be considered in adjudication of these claims, whether through OHR or through Superior Court, this effort might benefit from a roundtable discussion where all perspectives can be fully explored and considered. Thank you, Chairperson White and members of the committee for the opportunity to discuss this important conversation on improving human rights in the district. We look forward to working with the committee to further this goal, and I'm ready to answer any questions you may have at this time.
Thank you, Director Kine. I apologize. One of our witnesses had another name listed, so we didn't realize it was them. So I'm going to allow one of our public witnesses to testify as well, since I know he's done a lot of work in this area and was prepared to testify. So I want to welcome Robert Warren to make sure you have an opportunity to give your testimony. And I apologize that I missed you in the room earlier, and then we will come back to the director.
So yeah, thank you, Council Member. So good afternoon, Chairperson White, Council members, DC residents. My name is Robert Warren, lifelong DC resident, and one of the founding members of the organization People Fairness Coalition. Over the last 5 years, working along with members of the National Coalition for the Homeless, the National Law Center to End Poverty and Homelessness, and other coalition partners, we have been engaging the City Council here in Washington, DC, and the DC Human Rights Commission to implement the Michael Stoops anti-discrimination legislation to add homeless people as a protected class under the Human Rights Commission, so as not to be discriminated against while experiencing homelessness, housing instability here in the District of Columbia, a human rights city. This is not the original legislation that we had envisioned that had the late Michael Stoops' name attached to it, but I thank you. And I know it goes a long way into addressing some of our concerns when it comes to discrimination against people in the District of Columbia, men, women, and children, experiencing what we call homelessness. Once again, Councilman White, I'd like to thank you for your leadership in putting forth this bill that will build awareness, educate people of people being discriminated against, and some of the biases they suffer under here in the District of Columbia on a daily basis. As always, it is People Fairness Coalition's primary mission to bring about universal housing rights for lifelong and long-term district residents experiencing housing instability, to eliminate housing discrimination based on someone's income while we are living in a human rights city. This form of racial economic discrimination must end if we are ever to truly bring about racial equity in the District of Columbia and be an example for the rest of the nation. And with that said, I'd like to thank you again, Councilmember White, and those who have signed on to this bill to stand up for justice for the least of those in the District of Columbia, that they may not be discriminated because they are experiencing housing instability. Thank you again for this chance to testify, Mr. White. Just thinking about an experience, I've had recently when it comes to when you talk about policing in the community, I can remember numerous times a couple of my friends, being a Black man and, Muslim American, on top of that, and just going in a store, a Whole Food store with all of us kind of like with backpacks on and actually being followed around in the store and racially profiled by an off-duty police officer. And I had to kind of like tell my friends not to react to that because, I don't want to get into bad policing, and I really want to support our police officers more so now than ever before, just what they've been through, in the city, with the former guy. So, I think this legislation will go a long ways to just start to build awareness, and we can, educate the public because with these new engagements that we're having in the homeless encampments, with these pilot programs. And I know I was down there on site yesterday, and I guess it went as well as could be expected. But what I really didn't like to see was residents come out and make a scene down there and attack our police, and they're not out there, every day really trying to support that community. So, I was a little taken aback by that, and I do want to call that out, and that needs to stop. And we all need to be aware, because that biases and discrimination, sometimes we inflict them on each other. And so I think this legislation will go so far to start to acknowledge and start to heal some of those wounds. So thank you again, Councilmember, for your leadership.
Thank you so much.
Legislation about.
Absolutely. And thank you for your testimony and for your patience. When you got a common name like Robert, we got to be more specific. So Robert's iPad looks like my iPad. I appreciate your testimony a great deal. One quick question for you. And I was trying to glean this earlier, got some good recommendations. If this bill were to pass, what are your thoughts on how we would make the community aware of it, both individuals who are homeless, but also those who might need to think twice about discriminatory actions? How do you think we get the word out about this?
So I would just kind of follow up on Kate Coventry's suggestion, and throughout NH Council on Homelessness. I know we have a racial equity work group within that body. And we're, trying to really do some work and start to address some of the core agencies, in the continuum care who provide these services. Because me personally, I don't want to try to call anybody out, but there are some biases and some discriminatory practices that's kind of commonplace. There's some things that need to change. So I think we need to start there, and I think there's some accountability, but I don't want to be tokenized or used to check a box. And I think we start there, and we have what we call street sense media, and just just on the grassroots level, we'll get the word out. So we'll continue to try to educate the community. I know that there's a lot of folks, who in the community, we seen it just last night. We're in an AMC commissioner meeting on Ward 6. And, some of the community folks, they are, they have that NIMBYism, not in my community. And, just continue to build awareness, and I think we start with the NH Council on Homelessness.
Okay. Well, thank you very much. I really appreciate it, and truly appreciate all the work that you've done around this and helping us to get this far.
Thank you, Councilmember.
Thank you again for being here. Director, thank you again for being here and for your patience. Certainly, we want to hear from everyone. So let me start with some of the recommendations at the end of your testimony. It sounds like you're suggesting that amending the statutory definition of harassment and sexual harassment, you would prefer to be done as an agency rulemaking as opposed to legislatively. Well, why is that?
Yes, Chairperson, thank you. So because we think that will allow for more robust exchange of ideas on how to best improve this area of the law, would give us more time to engage in those discussions, and would allow us to really perfect the provision, and rather than rushing through it.
I would note that this is a roundtable on the bill and proposed language. So we've heard from a number of stakeholders, both in drafting, but also in the hearing today. So what would be different in the rulemaking process?
Sure, we would have, and again, more opportunity. Frankly, we haven't had an opportunity to discuss this with advocates or other stakeholders. And so we would like an opportunity to discuss this and flush this out a little bit more. As you know, the construction of the statute is very important in an interpretation of a given statutory provision. And so we want to make sure the syntax of the language, the uses of commas and ors and that sort of thing fall in line with the council's intention. So we want to understand more about council's intention, the purpose behind it, and work with, again, stakeholders like Mr. Puth from WILA and other organizations to align our interests and to discuss how best to really improve the law.
Okay. Well, I mean, I'll note just so everything's clear on the record, we introduced this bill in April, and so we have taken the time to hear from folks. We also do legislative drafting, so 100% with you on making sure that the terminology is correct, every comma is correct. It does matter, and it will matter for interpretation by agencies or courts. There, how long would a rulemaking on something like this take?
It would depend, Chairperson, on the ability to convene the stakeholders, to have the discussion, to draft it, and to have it be approved by the process that requires. So it would depend. But I think that the advantage of it is that we could truly sit down, spend some time to discuss all of the variations, look at other jurisdictions, which I'm sure the committee has done as well, but to talk about those various provisions in the other jurisdictions. Mr. Puth mentioned Montgomery County, for instance, to look at those other jurisdictions, provisions, and compare and develop the best language that is most workable.
Okay. Yeah, I mean, I agree on the process. I just think that the council is capable of and is doing the exact process that you're describing. And we do welcome input from the agency even after today's hearing, certainly.
Sure. And so I would add, council member, that, alternatively, that we have additional opportunities to work with the committee and again, other community stakeholders to have, again, more comprehensive discussion around the various legal consequences of the construction and the language.
All right. Yeah, we will continue to engage the community and absolutely welcome further discussions with the agency as well. One part of your testimony I'm really interested in. You mentioned that there might be someone better from agencies other than the current sexual harassment officers as defined by the mayor's order for handling this sort of accumulation of and reporting of data. Why, if there's already somebody at each agency identified as a sexual harassment officer, why might there be somebody else who would be better suited to collect and report this information?
Sure. And Councilmember, if I may, I might ask for an opportunity to get back to you on this more fully. Sure. Once I've had a chance to defer with our sister agency, Department of Human Resources. But I would speculate that part of that is access, whether or not the shows have full access to the information required under the proposed legislation. We want to make sure the person dealing with this and required to collect this data has the access to data.
Okay. Last October, the former Committee on Government Operations held a hearing on B23-195, which would have added homelessness as a protected characteristic under the HRA. At that hearing, the agency testified that the office was in full support of that proposal, subject to some funding considerations. Are you able to confirm that OHR remains in favor of prohibiting discrimination on the basis of homeless status?
Councilmember, I would say that we are working with other affected district agencies, and we just haven't had sufficient time to convene a full conversation around it, but I'm happy to get back to you more fully about that particular topic.
Okay.
And I would also add, if I may, that currently under the Human Rights Act, OHR has interpreted the protected trait place of residence to apply to public accommodations and housing area of discrimination cases.
Okay.
That would include homelessness.
And this provision has been in various bills over the years. I just want to make sure there's consistency in OHR's position, which at least last October was supportive of prohibiting discrimination on the basis of homelessness or housing status. So the Human Rights Enhancement Act would also clarify that for employment discrimination purposes, an employee includes someone working or seeking work as an independent contractor. As a general matter, do you agree that expressly protecting independent contractors from discrimination on the same footing as other employees would help advance HRA's stated purpose of ending discrimination on any basis other than individual merit?
So, Councilmember, what I would say is that, the reason why we said we needed more conversation around that topic as well is to understand what part of the issues with independent contractors we seek to address. So for instance, OHR, I can tell you, has interpreted our statute to include employees who have been misclassified as independent contractors when they are not, when employers have had control over their work, manner of work, time, location, supplies, all those sort of things. So we've considered those to be covered under the Human Rights Act and under the term employee. So we want to understand whether that's what the committee and the council are seeking to address, or if there are other issues. We want to understand whether it might benefit from having the term independent contractor defined in the statute by adding it to the definition of the word employee. We want to understand if it includes sole proprietors or people who. So I think ultimately it's looking at, are we concerned with employee-employer relationship versus consumer-vendor relationship, where the contractor might be more of a sole proprietor with multiple customers, and whether those are intended to be included in this addition as well. So we want to have a better understanding of those issues.
Okay. Do you have a take on Jonathan Puth's testimony? His interpretation of the current statute is that independent contractors are already covered under the HRA because it protects individuals. And so what we're trying to do here is sort of clarify what we believe is and should be a protection of individuals, regardless of whether they are sort of, traditional employees or individual independent contractors. Is that how you think we should be approaching the legislation, or how it should be interpreted or clarified?
So we've been interpreting these issues on a case-by-case basis. And as I mentioned before, some individuals are misclassified as what the courts have determined to be independent contractors, so these enumerated factors. And there are some exceptional situations in which the contractors should be covered under the Human Rights Act, and explicit addition of that language would be very helpful, certainly in the adjudication of these claims. But this is why I say that we could use a full discussion of these details to iron it all out. Mm-hmm. And I'm happy to further consult with my legal team, Chairperson, and get back to you more fully as to that response.
Okay. I'd appreciate that.
Sure.
Does the office currently track how many inquiries you receive that allege discrimination based on currently unprotected characteristics like homeless status? So, hard to say there are this many complaints for, this status if it doesn't exist, but I don't know if you all track complaints that are about statuses that are not protected under the HRA.
We don't technically track them, Chairperson, but I can tell you that from our anecdotal perspective, that there's been perhaps just a handful of allegations of homelessness, but I don't have the exact number, but we can certainly start tracking.
Okay. Could you provide a rough estimate of how many employment discrimination inquiries the intake staff currently receive in a typical year from people who might be classified as independent contractors?
I wouldn't have that number certainly today at this moment, but I may be able to gather depending on how that issue was raised, because this issue isn't going to come in and say independent contractors.
Yeah.
Go back and cull through some of these complaints and perhaps work with my legal team to see if they've been pulled in to advise about these issues at the intake level. But we could certainly look into it.
I appreciate it. Yeah, I understand that it sort of depends on what information was given and captured in the intake.
Right. It might come up as more of a motion to dismiss from respondents who allege that the Human Rights Act doesn't apply because you've got a contractor, independent contractor. So.
What position has the agency taken on that, whether or not independent contractors are covered under the HRA?
Great question. Most of the time, we've denied these motions in order to fully understand the factual bases, because that's what our work is based on, is to conduct a full investigation. And so, just like I mentioned before, sometimes where there is no control connection between the named respondent and the complainant, then we might find that there's no coverage. But we do look into this very, very carefully through the various stages of our investigation.
Okay. Earlier this year, Director Palacio indicated that past expansions of the HRA protections have prompted initial waves of cases involving respondents who discriminate after their continue to discriminate after the conduct becomes unlawful. So as the HRA protections are expanded, you'll see an initial wave of complaints, but then the volume of the cases taper off after the public becomes more familiar with the law. Is that generally what you've seen in your time at the agency?
I would agree with that.
Okay.
Of course, it would depend on, it's not a blanket finding, right? It would depend on the protected trade or the addition or the expansion, but generally I would agree with that.
Okay. So, is there a general kind of time period where it's like the first 6 months or the first year after an expansion of the HRA, you see a lot of complaints, but, it tapers off after a year, 6 months?
It's hard to say, Councilmember. With, for instance, FCRSA, we saw a huge spike in the first year of the implementation. But things like, for instance, Protecting Pregnant Workers Fairness Act, that continues to be a highly alleged allegation at OHR. So that's why I say it depends on the protected class or issue and the expansion itself. Okay. And part of the work we go into educating the public about these new laws as well factors into that.
And how do you go about educating the public?
We typically, as you might be aware, have standing HRL or human rights liaison trainings throughout the year. We fold any new laws into those trainings. We put out outreach materials. We also have a newsletter we put out monthly, which would include new laws. We conduct community events, and so we would include our new laws and discussions of those there. We do a number of trainings throughout the year within the government and within the community, and so we would fold in the new laws within those trainings and conversations as well.
Okay. And this may be similar to the previous question, but based on your experience with previous expansions of the HRA, about how long does it typically take for the public to kind of gain general familiarity with the new protections?
It's hard to say, and it depends on how active the community members and how strong the advocacy has been behind a certain issue. So I think, again, things like FCRSA was caught on very easily and early on because of the previous buildup of the movement to make that law. Things like adding credit as a protected basis in the Human Rights Act, same thing, because of the built up and movement to add that as a protected trade, easily caught on. But something different might be harder for communities to understand and realize. So it just depends on the subject matter. But we do our best to roll out information when the law becomes effective, and we get ready prior to the effective date in order to provide the information to our residents.
Okay. And if this statute goes is passed into law, how would the agency go about raising awareness and letting the public know about the new protections?
By this statute, I assume you mean the latter bill. For human rights.
Yes, I'm sorry about that. Yes.
No problem. And so we would do a vigorous amount of outreach and communication to ensure the public is aware of it, particularly since this bill has multiple parts that have different impacts, but very consequential parts to it. So we would have to make sure that we do aggressive outreach and develop materials. That's the other thing that I failed to mention earlier in our work, is that we constantly develop fact sheets and materials to go along with new laws, but we also issue what's called OHR enforcement guidance to provide any clarity to issues that might not be so clear in the statutory language.
Let me turn now back to the definition of harassment and how harassment gets tracked. You mentioned in your testimony the mayor's order 2017-313 to help protect district government employees from sexual harassment, and that includes a very detailed definition of sexual harassment with about 21 different examples and other details. Do you think it was helpful that the mayor provided district government employees with such detailed guidance on what to do, or rather on what not to do?
Well, I think it's helpful to provide examples of unwelcome conduct and intolerable behavior in the workplace, and the mayor's mission to have zero tolerance in the district for sexual harassment. If that makes sense.
Well, I have a couple more questions, so we'll
Sure.
flesh it out a bit. The HRA right now only mentions the term sexual harassment in the context of mandatory training for employers of tip wage workers, and there's no actual definition. Section 102 of the HRA says that unlawful discrimination includes harassment for a discriminatory reason. Does that include sexual harassment?
Yes.
Okay. So right now, if an employer wants to understand what kinds of conduct could constitute unlawful sexual harassment under the HRA, what could they do?
We would rely on judicial precedent and case law to review a claim for sexual harassment of a hostile work environment theory. And we do educate the public about theories of discrimination, disparate treatment, hostile work environment, reasonable accommodation, and so on and so forth in our training materials as well.
Okay. Who do those training materials go to?
Anyone who would attend our trainings.
Okay.
So again, as I mentioned, we do trainings for government employees. We provide trainings to the public in our HRL, human rights liaison trainings. And I might be missing a couple more, but I can certainly provide you with the fuller list when I get back to the other questions.
What about private employers? Are they privy to the training?
Anyone can sign up for these trainings.
Okay.
And of course, we do tend to work with DC Bar to provide trainings there as well.
Okay. So, I mean, I guess, it seems like there's nothing in the statute or municipal regs that would give private employers the level of guidance comparable to what the mayor has done for district government employers and employees. Is that something that you think we should take a look at?
Certainly.
When it comes to workplace harassment, do you think it's valuable for employers to be able to get a sense of what their obligations are under district laws without having to consult a lawyer or do case law research?
Certainly, I think more information is necessary and always useful. Raising awareness is always a good thing. In addition to case law, though, I would say there is guidance with the EEOC and to some extent our developing area of these OHR enforcement guidance documents as well. But I fully agree that more information and guidance is always useful.
Okay, but to your knowledge, there's no like specific reason that we don't do more. Is that right?
More in terms of
kind of training and guidance for private employers.
We could do more. I'm not sure that there's a specific reason why there isn't a focus on understanding, hostile work environment cases, for instance.
Okay. Under the mayor's order that we've been discussing, 2017-313, every district agency is supposed to notify OHR who its designated sexual harassment officer is, and to keep OHR informed of any changes. Are district agencies currently doing a good job of complying with that part of the mayor's order?
I'm happy to say yes, they are, council member, and we work very closely with DCHR to make that happen.
Good. From your review of the Sexual Harassment Data Collection and Reporting Act, is there any information that SHOs would need to collect about sexual harassment allegations that they don't already collect to be able to do their job?
Under the proposal, is what
Yes.
you're asking.
Yes.
One moment. Just want to refer back to the provisions. So shows may not have, not all shows, I would say, may have information about legal action, for instance, the financial settlement, and that sort of thing. So again, I would have to confer with DCHR to more fully understand what access and what information they currently have and what they don't have as compared to the proposal in the legislation.
And I mean, would you agree that as a best practice, SHOs should keep some kind of centralized log of ongoing sexual harassment inquiries within their agency so that they can make sure nothing gets too delayed or falls through the cracks?
Absolutely.
And if an SHO is keeping a regular log of any sexual harassment allegations, I do think that it shouldn't be too much trouble for the SHO to share that log with OHR. Does that sound reasonable to you?
Again, I don't think it's unreasonable to ask to have this data shared with OHR. I just want to have an opportunity to work with our sister agencies to make sure that we have the best individuals in place to collect the data so that we don't have inaccurate data.
Yeah. So I know we've discussed a number of follow-ups. Could we get those follow-ups from you next week so that we can make sure we have time to have further discussions with the agency to kind of review your recommendations, your answers for questions that need to be fleshed out, and that we have time for sort of a back and forth before moving forward?
Sure. Would the latter end of next week work for you, Chairperson?
Yeah. Can we say Thursday?
Sure.
Perfect. Thank you. Okay. Well, those are all the questions that I have. Is there anything that we haven't covered that you think would be important for the record?
I don't think so. Thank you for this opportunity. I look forward to working with the committee and the staff in developing this further.
Thank you very much. I look forward to working with you and the agency as well. So with that, I do want to thank both the director and the public witnesses and for joining us today. For anyone who wishes to submit additional testimony, written testimony is encouraged and will be made part of the official record. Anyone who is interested may submit their testimony by email to the Committee on Government Operations and Facilities at facilities@dccouncil.us. The record for this hearing will close at the close of business on Wednesday, October 20th, 2021. With that, the business before this committee is concluded. The time is now 2:36 p.m. and this hearing is adjourned. Thank you again.